Great.
Hello, everyone. Sufit here. I'm here today with Charles B. Ticker, estate mediator and litigator, and we're here with the second in our series, Mediation Minefield. What can make your mediation blow up or fizzle out without settlement? So today, Charles, I'd like to talk about a topic that is a little different than what we normally talk about. What would you do in a situation, or how does it affect the outcome of a mediation when one or more of the parties shows up either without representation, as a self-representation, or perhaps with somebody else who's not a lawyer? How does that often go?
There's no question that parties that are not represented by counsel at a mediation will tend to complicate things and make the mediation process more difficult and settlement more challenging. And this can happen in a couple ways. You may have a party who's actually a party to the lawsuit, but is representing themselves. So they've chosen to be their own lawyer. They've filed their affidavits, their pleadings. They've been involved from day one. And sometimes they do a pretty good job of it, learning the rules and how to file things, and sometimes they don't. But they're sort of like a little more up to speed of what the case is about. The other situation, which is more problematic, is where you have a party. Well, I shouldn't say party because it's not a party to a lawsuit, but you have a person who's invited to the party late. Okay, so they're an interested person, and they have some financial interest in the estate, but they're not a party to the litigation. But they're invited to the mediation either by counsel or by court order, saying you have a right to participate in the mediation. So they come to the mediation. They don't know really what the dispute's really about, or they don't really have a sense on what's transpired to date. They don't know any of the procedures. They don't know if they should file a brief, how to file a brief. And they're basically sitting there all day by themselves with no one to talk to. And at the end of the day, they're looking to you as mediator to provide them with some guidance or advice. And I have to be very clear. I'm not here as your lawyer. I can't give you legal advice. You're going to have to speak to a lawyer and get some advice. So what will happen quite often is, if the parties reach a settlement and there's a self-represented party, they're going to give that self-represented party an opportunity to go over the terms of the settlement with a lawyer and get some independent legal advice. And that could blow things up, or that could, hopefully not. Or you may want court approval of the terms of the settlement so it's binding on everyone. But sometimes you can have the situation where you have a person who really doesn't have a huge interest in the dispute, sort of, drive the process and become an obstacle to settlement. So I've seen that happen, and so it does pose a challenge when the party is not represented.
So Charles, what if one of the parties brings a neighbor who has watched every single episode of Perry Mason or Law and Order or whatever the shows are right now, sort of as his or her trusted advisor, not a lawyer, but sort of a know-it-all, or not, just someone whom the party trusts. Does that help or hinder the settlement process?
Well, I always encourage whoever's participating in the mediation to try and be as relaxed as possible and comfortable with the process. So if they feel more comfortable having a friend or a relative sit in with them, as long as the other parties agree, and as long as that person who they brought along signs the confidentiality mediation agreement, the confidentiality provisions, and signs as an observer, that's fine. Now, if that person starts to, think and play lawyer based on watching TV shows, that can be a problem, because, as we know, real lawyering is not like it's on TV or in the movies, although some films and shows do a better job of being more realistic than others, but it's not the same. And everyone thinks, well, I'm going to have my day in court, and they don't realize that it takes months or years to get to court, and your case is not going to be resolved in an hour like it is on TV. It could take years. So, yeah, it's, a little knowledge can be a very dangerous thing. So, as that can be a challenge sometimes if someone says, well, I read this case, or I know about what happened in this case, and then you have to explain, well, every case is different and we don't know what's going to happen here. But yeah, it can be a challenge for sure.
I imagine that would be a big challenge for the mediator as well, to maybe overhear incorrect legal advice from a so-called trusted advisor and not really be able to intercede and say, no, that's wrong, because that's not your role.
Correct. Yeah.
Yeah.
And sometimes you see that with parties who are represented by counsel as well.
Yeah.
And you're sort of treading a very thin line between giving legal advice or sort of just saying, well, this is my understanding. I don't quote me, but this is my understanding how it might work.
Right.
But yes, sometimes that's a problem too, if counsel aren't up to speed on the law. But
Oh, all right.
that happens, but it's rare.
And we're going to end in a minute, but I just wanted to ask you one more question. Would it be better if both parties were self-represented? I mean, assuming you're in a situation where one party is self-represented, does it work better when both parties are self-represented? Does it create an imbalance where one party has a lawyer and the other doesn't? Or, what would you say about that?
Well, I have been approached by self-rep or parties without counsel saying, "Will you just be the mediator?" And I tend to turn those down. I really want the parties to be there with counsel, because my experience, if you're dealing with people who don't have lawyers, they're looking to you as a mediator. They know you're a lawyer, and they're going to start relying on you. Even you can tell them, "I'm not your lawyer," but at the end of the day, they think you gave them legal advice, and it can create all kinds of potential liabilities for the mediator, and not to mention aggravation. So I know I've seen it done, and I know it happens quite a bit in the matrimonial context or divorce context, where a mediator not only meets with the parties but helps them draft the settlement agreement, and then they take it to their respective lawyers to review. That's not my practice, and it's not something that I would want to do as a mediator, to be actively involved in drafting a settlement agreement. Sometimes counsel asks me to look over the minutes of settlement, and I may give some comments saying, well, you forgot this point. You guys were talking about this point. They say, oh yeah, we'll address that. But I really, don't see my role there as playing lawyer or drafting agreements. My role there is to facilitate the settlement discussions.
There you have it. Our guest today, thank you very much. Our guest today has been Charles B. Ticker, estate mediator and litigator, and you have heard another episode in Mediation Minefield: what can blow up your mediation or make it fizzle out without settlement. Charles, thank you very much.
My pleasure.